my court, and I would run it in the way I see fit. And if you don't like it, you can leave.
Is that right, sir?
Practicing law from the bench, right? I think you can't have you practicing law from the bench. If you run attention to me like that, Mr. Timmy, I'll hold you in contempt and have you detained. Stop wasting my time.
Oh no, nothing's worse than Timmy with authority, huh?
Bye-bye now.
Timmy.
Cool. Ready?
So yeah, basically what happened with the original hearing was
Judge Timmy Black. Yep.
Yep. So many a time before, I put it into a memorandum and under recusal, and I went and did it under because I'd spoken to another senior court officer, and I was told Senior Courts Act, do it under the Senior Courts Act. So I did that. And then he accepted the recusal application, and then the father's lawyer complained that it wasn't under the right section.
Right.
It wasn't under the right act because the senior courts is for the senior courts according to him. Right, but it had been accepted as coming through, and it's supposed to be like, okay, going on her rendition of how things should be. That would mean that in the High Court you can't use anything but the High Court rules. In the District Court you can't use anything but the District Court rules. However, we all know if that was the case, then how would you bring a criminal case into the crime?
Well, yeah, and you have to bring the High Court. You can bring High Court rules into the District Court. It's just you can't do it the other way round. The child doesn't get to tell the parent what to do, so to speak.
Yes, exactly. So it ended up being, I thought, right, well, just for completeness, I redid the application and did it under the District Court Act 2016, I think it is.
Yep, that is. Yep, that is.
Section 217, and put it in that morning. Yep. So that there was one to go into that. I think it was in the afternoon. And to his, I could tell to Judge Black's disgust. Again, you put the right bloody application in. Now I've got to deal with it.
Yeah, right.
So, so I put that in.
Well, he can thank the other lawyer for pointing it out to you, so you got it correct, and that fucks him right off. He has to deal with it.
Well, yes, and that was what was happening a lot within the actual recusal hearing. So every single part where he was talking about what I had put in the application, yep, he kept on looking at the father's lawyer, as if to say, chime in, this is half your fault we're here. Yeah,
exactly.
And
you've got a tort of professional negligence against that fucker. So
yeah. So when it comes down to when it came down to it, the one thing you learn through going through that kind of stuff is these judges are so picky, especially Black. He's just not going to recuse himself. It wouldn't matter what you do.
Oh, ego the size of fucking the size of Auckland Harbour Bridge, for fuck's sake. I mean, it's...
Yep, and so what ended up happening at the end of it was, to my surprise, like I was literally waiting for him to go, Mr. Andrews, you're in contempt of court. That's what I was waiting for.
Yep.
And to my surprise, he just said, no, but that's not where this is finished. And then he carried on.
Right.
And then he went on about the fact that I'd made 8 judicial conduct complaints, and that one of those was now subject to a judicial review.
Oh,
and
well, he should have done his job properly, quite frankly, then, shouldn't he? And not given cause for those complaints to have to be made.
Well, yes, but you see, what I think the important thing to note is when I got, like, I'll admit it, I did 12 complaints in less than a year against him. Okay, but that's because, okay, I started off the same way everyone else does. And what I did was I went, okay, this is what he was doing in the courtroom.
Yeah.
And these are the procedural steps that should have been taken. So over time, I came to realise, and even Alan Ritchie himself wrote it in one of the decisions, that he noted I was no longer making reference to the sections of the Judicial Conduct Panel Act anymore.
And Alan Ritchie is the chair of the JCC, isn't he?
Yeah. Right. And so he found it apparently very interesting that I was no longer using the sections within the Act to bring forward complaints, and that they had now moved to simple, very simple, straightforward conduct complaints. the way the judge was conducting himself in chambers. And he tried to quote me on 16.2F. And I turned around and said to him, no, that doesn't apply. Because
and what's 16.2F?
Okay, so what it says is that a judicial conduct commissioner, it's either 8 or 16. One of the two.
This is the JCC Act. JCC Act we're talking about.
JCC Act.
Yep.
So what it says is that the judicial conduct commissioner cannot take into consideration any decision made by a judge, any procedural step, anything to do with law that's happened in the courtroom. Any direction that a judge has given, any memorandum that a judge has given. Right? So I just copied and pasted that particular part of it, put it into my complaint, and said I am not, for the avoidance of doubt and completeness, I am not, this complaint is not in regards to this. It is simply in regards to the tone in which it was delivered within chambers. So he came back with, I'm sorry, but I just cannot agree with you. That it is obvious to me you are asking me to look at this section and redo it. So going on that, why did he then follow up with, I have got copies of the recordings, and in my view, the judge did not use harsh tone. So on that, I judicial reviewed it.
So what did he actually do? What did
he did nothing.
No, I mean, what did Judge Black do? What was the tone? What was he talking about?
Okay, when someone turns around and says this to you, okay, like in December in the court hearing, he didn't like that my daughter turned around and said, "Well, that's your interpretation of the Carrot Children Act. Yeah. I have my interpretation. You have your interpretation, Judge Black.
Right.
Well, that's my interpretation, and I'm the judge, and that's all that matters."
Exactly. That's how he rolls.
But it wasn't. But it was the way in which he said it. Well, he goes, well, that's your interpretation, and this is my interpretation. I'm the judge.
Yeah, exactly. Because, I mean,
so,
you can read any transcript in the world, and it doesn't show the emotion or the tone that comes with the language. All it shows you is black and white. It doesn't show you that.
You've brought up a very perfect point that I've just adjusted in my judicial review, and that is this. Okay. The conduct commissioner can sit there and listen to as many recordings as he likes. The issue I have with what he's done is you are not in the courtroom, therefore you do not know how the individual was made to feel when the judge came across in a threatening manner. A judge is not allowed to threaten, intimidate or bully, and you weren't there on the day to know how I felt.
He's got to be subjective. And he wasn't there, so he can't be subjective. All he can be is objective towards it.
As far as the Judicial Conduct Commissioner is concerned, I listened to the recording, and he listened to the recording, and there is nothing in that recording that causes him concern on how a judicial officer acted. Yeah.
Okay. So of course you're doing a judicial review on that decision.
On that one and another one.
Might as well be thorough.
But between two judicial reviews that have been merged is 11 points.
Right. There's quite a few.
Because at the end of the day, the Judicial Conduct Commissioner is supposed to be there to manage, well, in my view, manage the conduct of judges. And if they can't control themselves in the courtroom, then they need to be pulled from their position and retrained or whatever it means.
Right.
Okay, you can't just turn around and sit there acting like a gatekeeper, like you have been for how many years since your position became available.
2017.
I know.
Either plead guilty or not. I don't care what you plead. I'm not going to have this discussion with you. If you want to test jurisdiction, see how you've done with the PINAC.
Is jurisdiction not allowed to be challenged at any point during the proceedings, Your Honour?
You can test that, Mr. P, if you think you can get away with trying to test it as a PINAC.
Objection, point of clarification.
I'm not entertaining a discussion about jurisdiction today, Mr. P.
Why is that?
Because this is my court, and I will run it in the way I see fit. And if you don't like it, you can leave.
Is that right, sir?
Yes.
Can I have a copy of the order that you issued the security to have my recording equipment removed from my
I
possession?
simply made a direction.
I was told you had given an order for me to have my equipment removed. Well, I'd like a copy of that in writing, please, Your Honour.
You can make a request in the normal way.
Well, I was told by security to ask you for that now.
Well, it's just an email.
Yeah, I would like evidence of that, please, sir.
I've got the email. Probably on. I haven't got it immediately in front of me.
So where should I inquire?
You simply email the registry and ask for a copy of it.
I have asked this court for many things and not been supplied anything in regards to that.
That's what you asked them for.
I've asked them to establish, well, I sent them 21 questions and haven't got any answers whatsoever. Just silly tactics because I told you.
Questions, Mr. King, are absolute nonsense. And you're wasting your
How is
time.
the jurisdiction of this court or of the New Zealand courts nonsense, right?
30 seconds and I'm entering a deed not guilty plea. I'm not having this conversation. I'm not wasting my time with someone who wants to have some.
I wish you were fully informed, please, Your Honour.
Deed not guilty.
Are you entering a plea on behalf of Your Honour?
Yeah, because you're refusing to enter a plea.
Are you practising law from the bench, Your Honour?
I think you can't.
Are you practising law from the bench? Are you representing
Be like that, Mr. King. I hold you in contempt and have you detained. Stop wasting my time.
3,500 complaints. So, with all of those 3,500 complaints, why have none been upheld?
Yeah.
Let me guess. Is it just because, okay, as long as they kiss his ass, he'll kiss theirs?
Well,
Because
Amanda,
that's all it comes down to, really.
Amanda did all of that background work, mate. She found out that she just went through all of the judicial conduct sort of annual reports that came out, and it showed you all that information. And yeah, it was up to 3,700 now complaints that were just not upheld, and
but
0 or 1.
But the reason that they're not getting upheld, see, this is my understanding of where I'm at so far. I've just finished off amending my statement of claim to add in the second one that the Justice asked me to add in, 17th of April one that they reckon wasn't filed. Now, my understanding of what's supposed to happen from here onwards, I file it. The record, give this, you know how I was talking about the records of the decision? Right.
Yeah.
What a joke. I had already filed it.
Right.
So where the JCC was, the lawyers said we have to file a records of decision, I've already filed all that. So I don't know what the heck they were doing, but he said it to me on yesterday, and I'm looking at it going, so you just wasted our time for a week on shit that I already gave us. Okay.
Wankers.
I mean, as you know, okay, if you get a judgment, you have to turn around, and if you're just reviewing your appealing, you've got to give a copy of that judgment to the court so they know what you're appealing or judicial reviewing.
Right.
Okay. The JCC council made it sound like there were specific reports that were coming along with it. Although they're trying to play a very dirty game at the moment. What they've done is they've added in the minutes from the complaints that I get, right? On the basis that they'll try and draw along those minutes, saying that on the minutes saying that these are the directions he's challenging, right?
But
so
you're
I'm
not
using
challenging. You're not challenging any direction. You're challenging the conduct.
That's right. And so when I saw that within the paper, it was like, okay, you want to play those things?
They're trying to move the goalposts on you, bro.
That's right. So what they're trying to do is use the minutes to say that no, he's actually going against the directions, and that's what Section 8 says you can't do.
Yeah.
Right. And so I've already addressed all of that within my amended statement of claim, on the basis that no, you as the JCC representative, your counsel, you put that forward, not me. So at the end of the day, show me in my paperwork where I supplied those decisions. I simply gave the conduct decisions, and I didn't supply the minutes because there was no point in supplying the minutes because it had to be based off the Judicial Conduct Commissioner's decision.
Yeah, well, that's what it's. I mean, they decided to call it that, not you. They called it the Judicial Conduct Commission. It's not called the Judicial Complaint Commission or Direction Commission.
Yeah, so what's ended up happening is I've ended up rewriting the statement of claim, basically turning around and stating that he's not in the position to be a gatekeeper. He's not there to cover the asses of the rest of the judiciary. He's there to, and it's impossible for the public to have any confidence in the judicial system if we're going to have a Judicial Conduct Commissioner who is only there to gatekeep and keep the judges into their job.
Yeah.
Because that's not the whole point of the position. The point of the position is if someone has done wrong, they must be reprimanded.
Well, correct.
And so if we're not going to do that, then what is the point of having them in that position?
So what's going to be the end result there?
Section 17, subsection 2 of the Act, where it gets referred to the heads of bench.
Right. So
the normal step process is if you make a conduct complaint, and it's plainly a conduct complaint, Alan Ritchie doesn't have any discretion to go, no, I'm not going to
must be
that.
sent to the head of the bench.
Yeah.
Yep.
So I'm seeking that it goes to the heads of the bench. I've been told the relief will be granted. I've just got to wait till we have to go to the hearing stage to get it formalised.
Sure.
Because even though this council saying yes, okay, we're not opposing, it has to go to the formal hearing to be able to get it all done.
Of course.
Fine by me, not a problem, as long as it gets done. Because at the end of the day, that's progress that has never been made before, going by what I've read up on NZLII. Everybody's that's done a judicial review on a Judicial Conduct Commission complaint decision has failed.
Right.
So on the basis that it was not a judicial conduct complaint, it was a procedural step complaint. So what people have to be able to learn from it really is, if you're going into a courtroom and you say, like the minute you turn around and say, well, the judge should have done this, that's not what you're saying. What you're saying is, you're looking for where he or she is not conducting themselves in the correct manner within the courtroom. Don't look for anything to do with law.
Yeah, I mean, you go by the Judicial Conduct Guidelines 2019. Like, you just cut and paste sections from it and put it straight into it.
Yeah, but the hard part is when you look at the Judicial Conduct Guidelines 2019.
Yeah.
Okay, it says if a judge forms a view. Right. So you've got to be careful when you start writing documents in that manner, because if the judge formed a view, what did they form a view on? What particular part of the Act was it about?
Exactly.
And now we're back into procedural steps.
Right. So they drag you back into it, and you need to stay focused narrowly on the conduct.
Yes, and so that's what I've learned over the last 5 or 6 months, and that's where the conduct complaints were hitting black hard, and that's why I think we decided it's time to move on, because it's getting too close to getting further on.
Right, so he denied all of your different points and grounds, and then...
Oh yeah, he denied the whole lot. He just said he was not prepared to recuse himself, and then he just went on to say, however, he's declining to have further involvement with the case because there was 8 judicial conduct complaints. One is now subject to judicial review. Then he looked at me and goes, Mr. Andrews, you, sir, are a bully, and I am not prepared to be subjected to ongoing personal attacks to my integrity. That was when I felt like standing up and going and saying to him, what integrity?
Yeah, exactly. Exactly. So he basically played the victim card, gaslit the record to say that you're the one that's being the bully. Certainly not the correct conduct of a judicial officer to be accusing of an applicant in that manner. So,
well, considering he's got at least 8 of the conduct complaints are actual conduct complaints. The first 4, I admit myself, they are more procedural step ones where he buggered up. Yep. When I realised I can only go by the judicial conduct.
What can you do about the procedural steps if they bugger up? If the JCC won't deal with them, who do you complain to about the procedural steps not
So the
being
procedural steps is a judicial review, because judicial reviews deal with procedural steps.
Okay.
You'll get a lot of people that go, no, they don't. But in my dealings that I've had with the court so far, appeals deal with the evidence and the mainly with the evidence, and the judicial review is you're reviewing how did the judge get to that decision using the procedural steps.
Yeah.
A lot of them turn around and say, well, it requires evidence to do so. I don't, personally myself and what I've been going through with it all, I don't believe that's the case, because if that was the case, then when I had done that judicial review last year and then got the consent memorandum, it was based off of the fact that the judicial review that I'd written, the council decided, okay, there was no prospect of success, and that's why the return home should happen.
Right.
So it's it was just being able to call them out on the fact that, okay, now the judge has got it completely wrong, and
so he recused himself anyway, just not because of your application, but because he was playing the victim and said you're being the bully, even though clearly it's his courtroom, so anything that goes on in it clearly
Well,
it's his fucking responsibility. He's always said, this is my courtroom, if you don't like it you can leave.
It should be my court, and I would run it in the way I see fit, and if you don't like it, you can leave.
So,
well, I mean, the other way to look at it is this. Not only is it your courtroom, his courtroom,
yeah,
it's your system. So if your system screwed you over, sorry I used it correctly.
yeah, exactly right. Don't blame us. We didn't make the rules. We're just following them. And if you guys don't read the rule book as good as we do, well, sorry, you lose. It's a simple game of chess.
In a way, what it comes down to, it's sorry that I was able to implement shit that you don't use every day, just simply because you've got a whole pile of officers of the court that come before you that are willing to bow down to you and just use the sections you require them to use to make your life easier. Sorry, I don't have the ability to do that. There's many other sections for me to use, and I will implement them to the best of my knowledge.
So now you've got torts of professional negligence against the lawyer for child, the lawyer for the other party. Are you going after any of the OT staff, and perhaps a future tort of negligence against Timothy, perhaps?
Oh yeah. I mean, that's going to be
That's going to be a beautiful one. That's going to take a long time to write, considering the amount of crap he's put you through in 3.5, 4 years.
Well, yeah, and with what, close to 5,000 pages.
Yeah, it's going to take a long time.
It's going through and working out which is the ones that are going to have the most weight, and then being able to apply the law and everything to them to be able to have it successfully done, and also to connect the cause to action.
To implement them in the right steps so they all make complete sense. Well, the only way to do that properly would be chronographically, surely. You just go by the dates and show how it unfolds.
Negligence, when I was reading up on the document and talks of negligence, and I've got to do this one in the one I've got to do by Friday, is you've got cause to action, right? So in your cause to action, what you've got to be able to do is you've got your background timeline, right? Now, what you've got to then be able to do is between the cause to action, which is negligence, and so even though it's a sort of professional negligence, the actual cause to action is negligence. So from the cause to action, you're then going to move down to your background timeline, but basically lay out what has happened, why you say that this is important, in regards to the cause to action.
Sure.
Then you've got to move to your causation to injury. Right. And then, so what you're doing is the cause to action and your background timeline to be able to say what happened and what the person did wrong.
Right.
Okay. Then you're showing how did that cause you injury. Now, not injury as in injury as such, but it can be, you got hurt, you lost money, the child wasn't with their family, that kind of stuff.
Yeah,
right?
psychological injury, that sort of thing.
Yep.
Emotional harm, I think is the correct term.
All that type of stuff. Yep. So what it ends up happening is you're linking it all together, right? And then at the end, what they how we call it, it says at the bottom, relief sought, right?
Yep.
They call it prayer relief sought.
Okay.
Right?
The difference being?
It's still written as relief sought, but what they're saying is you have to show the court why you say the relief that you're seeking is the appropriate relief for the neglect.
Just to justify what you're seeking. In other words, right.
So that's fully what's got to be done on the tort of negligence. And so far there's the one that I've got to fix up by Friday, well, that's all good. And then I've got the other one we're waiting on to have a CIV number assigned for. And then there's the one we took against the criminal registrar at Lahan.
Oh, that's right, because you're dealing with the registrars as well. You put some of them under a tort.
Amazing though, you put one in against one registrar, all of a sudden the whole registry wants to be nice to you.
Yeah, it's a shocker. It just shows that you're not dicking around.
I think what it came down to is we always used to turn around and say, look, if you're not going to do your job properly, we might end up making proceedings against us.
Oh, yeah.
And then now that we've actually done it against one, all of a sudden the rest of the registry is like very, very
They're all pulling their heads in. Like what were you telling me about Manukau registry? Because you're like down in Lower Hutt. So what?
Oh, I dealt with there was one in Manukau registry and one in Whangarei registry where I'm pretty sure the one that the guy had ginger hair, because I had a person video them,
right?
And because she was doing care children application. That's what this one's in Manukau.
Yep.
And she spoke to the registrar, and the registrar said no, she couldn't accept the paperwork that was filed,
right?
She was trying to discharge OT orders and get a Care of Children Act custody order.
Right.
And I said, the best way to do it, she says, even though you've got a Care of Children form, she goes, yeah, simply write in the box where it says what orders you apply for, Otho Company Act 1989, Section 125 discharge. And she goes, yeah, that way the judge is going to be less confused as to what the heck is going on, because they're going to realise that, okay, if there's an Otho Company Act order, Section 120 says you can't apply under the Care of Children Act for a custody order, unless there's a discharge of it. And so she had this discussion with the registrars, and they were going, no, she goes, well, I want to get the person on the phone that has been helping me with that. And so
She gave you a call.
She gave me a call, and I was talking to the lady on video call, and she listened to everything I had to say. The family court coordinator was sitting a chair behind her listening to it all.
All right.
And what got me the most was, she was obviously in training, but the family court coordinator, who should have known what I was talking about, they had to go away and get a registrar because they had no idea that that's over our head.
Yeah.
I was like, how's that even, you're dealing with it every day, family court.
Yeah. Because you're using sections they're not aware of.
Yeah, well, because she turned around and she said, like, no, I don't believe it can be done that way. It has to be done on the two separate forms. I said, normally, yes, that's what it would end up happening, but on a without notice, if you put them together, if you put the two separate forms in, your G6 form and then your Care of Children form, the G6 form will cancel out the Care of Children form, and so it will add 6 months onto the journey for the whānau trying to get the custody. It won't happen straight away, because what will happen is the judge will get confused and go, what are they actually applying for? Discharge or custody, which one is it?
Yeah, exactly.
And so on that basis, what they will normally turn around and do is they will say it doesn't meet the requirements of Family Court Rule 222A2, and on that basis they're not going to grant it without notice.
Right. So you should just stick with the discharge.
Well, no. What I said to you was, like, you know how we did you remember the Hastings baby case one?
Yes.
Right. Okay, and we put the 125 discharge, and then we put the Care of Children Act. And then the judge went, okay, I'm going to call a Pickwick hearing.
Right.
And so they held the Pickwick hearing, right? So that's why I tend to do them that way, because it grabs the attention of the individual that's reading the document.
Good.
Because, okay, why is there all of a sudden this here when there's been no mention of it before? I need to get the parties in urgently and deal with it.
Yeah, so instead of her filing it where there was one for guardianship and one for discharge, what one should she have gone with?
I said to her, just stick with the Care of Children Act one. She was long as
Which is the guardianship.
She sent me the on the Care of Children Act was custody and guardianship.
Custody.
But the what happened was she sent me her copy of it through PDF. So I used the Adobe Acrobat and just typed in Otho Company Act and put Section 125 discharge on the actual order part as well.
Right.
They refused to accept it, and I turned around and said, okay, second, what's your refusal to accept it? Because it's not under the Care of Children Act.
What's the ground?
I'm aware of that, but I said to them, this is something you as the court staff should be aware of, don't you? The Otho Company Act is based off of the Care of Children Act. The Otho Company Act is simply the care and protection version of the Care of Children Act. And if you want confirmation of that, go to Section 101 of the Act, which will tell you that Section 104 is implied in the way that Section 48 of the Care of Children Act is. Just like the guardianship under 110AA is done under 27.1 of the Care of Children Act. It says it in the OT Act, and she goes, yeah. So what that's saying is, it is reliant on the Care of Children Act to implement the OT Act, the care and protection part.
Yeah.
And she was like, oh, okay. And I said, you've only got to look at it to see that the OT Act is only a care and protection version of the Care of Children Act. It's based off the Care of Children Act.
It's secondary to the Care of Children Act. So the Care of Children Act must be implemented first and then go into the other.
Exactly. But the courts don't want to hear it from that point of view, even though it's written in the legislation like that. Right. I mean, like, it gets very simple when Section 104 of the OT Act says that a 101 is the same as a Section 48 custody order under the Care of Children Act. You can't get much plainer than that when it says that.
Sure.
So, but the courts will always try and say, no, it's the 101 is an OT custody order. Yes, it is, but it has the meaning as is defined in the Care of Children Act, Section 48.
Yeah.
It's very clear.
Yeah. So they don't want to go. They don't want to go back and look at that.
When you bring arguments forward like that, they don't like that because it's not the norm. It hasn't been like that for 60 odd years. Realistically, if the family court system worked the way it was supposed to have been done, like when it first started back in 1978 they created the guidelines for family court.
Right.
And the guidelines, when you look them up, clearly, I mean, this is in a way how I managed to be able to make sure we got other homes. I looked at everything and went, okay, I'm going to try and implement what they were doing in 1978 and see if it works.
Right.
And all it is, mediation, followed by final consent memorandum to be signed by a judge. Right?
Exactly.
So, all I actually did was repurpose.
Sorry, and in that simple description you just gave, I didn't hear anything about taking your child away from the parent.
That's because there is nothing to do with taking the child away to do it.
But that's the first thing they do.
Yes, but you see, when it came back to 1978, okay,
Yep.
we've got to remember that the OT Act part of it. Now, this is the kicker part of it, right? The OT Act is not actually based off of the OT Act and the Care of Children Act originally. It is based off of the 1968 Guardianship Act.
Okay.
And so the Care of Children Act that we have now was originally the 1968 Guardianship Act. So when you were dealing with guardianship back in those days, there was no custody.
It was just guardianship, and that meant you've got everything, including the custody.
Yes, and then what ended up happening was they changed it around so that it went to custody, right? Because guardianship is defined as detaining an individual, and it's illegal to detain.
Which is a breach of Section 22 of BORA.
Yes, and it actually comes under the Magna Carta in that as well.
Yeah, they don't like it when you bring the Magna Carta in, though. A lot of them will just ignore the Magna Carta being dragged in.
Oh, exactly, yeah, exactly. But when it comes down to it, it was just the interesting phase to go through on the journey to find out, well, hold on a minute, the family court originally started in 1978 as the umbrella of the district court, which surprised me because...
so it's a secondary court to the district court. So surely...
Well, I remember my mum having, back as what they termed as custody back in those days, custody in 1975. So to me it was sort of, how'd they get 1978 then?
Must have done it a different way. So what was done pre-78 before the Guardianship Act?
No, everything was done under the Department of Social Welfare back then.
Yeah, of course.
Yeah. So the Department of Social Welfare, they were under the Social Security Act, and so all of the stuff that was to do with custody was under the Social Security Act.
Right. That's sort of like the primary one for all of them, isn't it?
Yes.
Oh no, nothing's worse than Timmy with authority, huh?
Bye-bye now.